Now we're going to talk about the history of people who were diagnosed with some type of exceptional need. We begin over 200 years ago in 1799 with Jean-Marc Gaspard Itard. And this was a person who was looking at explicit instruction. Actually, he was a person who was looking at mental retardation within populations and trying to figure out how we could use explicit instruction to help people understand when they were cognitively deficient. Then we started to see some inconsistent opportunities. In 1948, only 12% of all children received services who had some type of mental retardation, while in 1962, 16 states actually had laws that included the mental retardation population. So within those jumps, you go from 1799, where there's one person looking at explicit instruction, and nothing happens until almost 1948, where then all of a sudden we have this diagnosis. It takes another almost 15 years before states start to put laws into place to help protect these groups. The national legislation that happened over history is found on page 20 and 21 of your textbook. So what are some landmark events that we should consider? Well, the first had to do with the 1960s, looking at environment. The 1960s spent a lot of time trying to figure out what was going on around the child that may be impeding or that could help the child improve their learning. So we considered lack of early stimulation and a low socioeconomic status, which meant that children may not have the opportunities that children with a higher socioeconomic status might have. This saw the beginning of the Head Start program. This is a federal legislation that still continues today to provide money to give opportunities for new parents, parents who do not have the money to buy books, take their children to museums, pay for daycare or other early stimulation, and provide them with the opportunity to have these experiences. Well, then we moved to the 1990s, where we weren't sure that it was really the environment that was causing these issues, more a genetic issue. So we started looking at heredity, family background, and trying to figure out if what was happening was something that was being passed down from generation to generation. Finally, we moved to the 2000s. This is the incorporation of both the environment and heredity. The view really is more of an intra-individual difference within the same child. In other words, what are things that are going on around the child and yet hereditarily that could be causing issues? Are they working together? Are they working apart from each other? And so the view really has to do with planning for success. What are the strategies that are going to be put into place? What types of medications can be used? What family history is helpful that we can create plans so that these children can be successful? Next, I'd like to move into the historical overview of educational acts. The first one has to do with the 1957 National Defense Act. This particular act prioritized education. It said that things were happening in other places in the world where we were concerned that we as a nation would fall behind. Therefore, a lot of emphasis was placed on education, specifically math and science. Next, in the 1970s, you had PL 230, Public Law 230. This is the Education of Handicapped Act. Specifically, it was written to assist the states in providing a free and appropriate public education to children with disabilities by establishing minimum requirements that needed to be offered within those states. In 1973, you saw the emergence of the Elementary and Secondary Education Act, ESEA. Now, granted, this particular act was signed into law in 1967. It was the first real federal funding that was provided for different states to help children who all needed help no matter what their socioeconomic status was or their disability. When we look at the 1973 version of ESEA, there was a section of 504 that was added. 504 was added, and what it basically said was that this was a civil rights issue. This was not just people who happened to be born into situations or with situations that could impede their learning. This was something where we could not, as a country, allow this group of people to not be educated to their fullest. It was an accommodation of school within society. In 1975, we ended up with the landmark case of PL Public Law 94-142. This is the Education for All Handicapped law. At this time, the different Individuals with Disability Acts that you see in place now, both written in 1990, 1997, and then revised again in 2000 and 2004, really based free and appropriate public education as something that was vital to the success of our nation. We started identifying children in schools, had the federal funding, and the paperwork that was going to create individual learning plans for these children to be successful. In 1986, there was an amendment to the Education for All Handicapped Children Act, PL 94-142, and this meant that we weren't just going to be looking at children who were entering in kindergarten and leaving when they were 18, but it extended these services to include infants and toddlers. The list of services added in 1990 under IDEA, Individuals with Developmental Education Act, expanded the learning opportunities for children. The transition plan was created and put as a document to support children's transition from one learning environment to another. The stages included preschool to elementary school to middle school to high school, and high school to career. Although many children diagnosed with special needs did not attain career status when they transitioned into adult life, it was important to consider what skills they were going to need to be able to be successful. The Americans with Disability Act protected individuals with disabilities from being denied employment, transportation, accommodation, telecommunications, and it was the intent to ensure that all children and individual civil rights were being protected. In 1997, we saw this change in IDEA. This tended to look at including children who had a medical diagnosis of attention deficit with hyperactivity disorder. In addition, a variety of accountability measures were also put into place. The functional behavioral assessment provided information and clarification about undesirable behaviors that we wanted students to be able to work on and diminish. The assessments led to behavior plans that include goals that focus on self-control, reduction of violence, and other social concerns. Well, IDEA, Individuals with Disabilities Education Act, was reauthorized again. One of the things that happened was that in 2004, we started looking at the fact that special education teachers needed to be highly qualified, and that children who have special education plans needed to participate in their learning with children who did not. We also included RTI, which is response to intervention, as a way to identify and to support children with a learning disability diagnosis. Finally, alternative education was provided for students who brought guns, who brought weapons, who brought drugs, or who committed some violent act in schools. Leaving special education for a minute, we do need to realize that there was a reauthorization of ESEA, the Elementary and Secondary Education Act. That first act that provided federal funds to help all children, This was reauthorized into NCLB. You may have heard of this as No Child Left Behind or Nickelby or some other reference. NCLB added accountability measures to require the states to improve student learning across the board. This meant that children who did not have a special need had to maintain or increase their functioning in academia based on standardized tests. When this was put into place, the special education group was left out. Now, NCLB includes children with special needs. They also must get accommodations for these state tests, but must participate in all of these tests. It's 2011, Barack Obama is in office, and NCLB is being revised again. We are now looking at the blueprint for education. This is not completely defined as of yet, but it's something that you need to be paying attention to because it will change the type of accountability measures that are put into place. So let's look at some lingo. NCLB, No Child Left Behind. ESEA, Elementary and Secondary Education Act. ADA, Americans with Disability Act. LRE, Least Restrictive Environment. And FAPE, Free and Appropriate Public Education. NCLB was just described as the reauthorization of ESEA, the Elementary and Secondary Education Act passed by President Johnson in 1967. Americans with Disability Act was written to help those who had the physical disabilities and gave them access to buildings and participation in a variety of different learning venues as well as work. LRE, the least restrictive environment, was the first thing that was considered when the PL 94-142 was passed. That means that students had the right to learn in what was considered the least restrictive environment for them. That might mean that they learn in a general ed classroom with supports. It might mean that they learn in a resource room with a limited number of students. It might mean that they learn in a self-contained room, a room where children who have the same diagnosis as they do learn at the same level as they do. Least restrictive environment is one of the things that's considered when giving children who have a special need diagnosis a learning plan. The last thing that is considered is FAPE, Free and Appropriate Public Education. This means that parents do not need to pay out of pocket any more than they would for a children who does not have a special need. So, parents today, you tend to pay for your textbook fees, you pay for your lunches, you pay for your yearbooks, those types of things. Children who have special needs may need other tools. They may need computers, they may need voice activation, they may need braille writers, they may need Wi-Fi systems, they may need large print books, and all of these things cost money. This money does not come out of the parent's pocket. This money comes out of the state pocket. If the state does not have the dollars for it, then the school district is responsible for finding those funds as well. This is the end of the overview of the history and some of the court cases over the past that have influenced special education in the United States.